This is our last CPD topic of the year, to be presented by Michael Cranitch and Andrew Campbell over here on the topic of birth torts. A funny aside before I commence introduction. Phil, welcome. Michael pulled me aside after the last couple of presentations and said to me that he wanted to get away from the abstract nature of topics like free speech and what it means to be a citizen, the intersection of religion and law. For those who weren't here, they were the sort of topics that we dealt with last time, and yet in doing so he's chosen a topic that throws up the most metaphysical of all questions. Can the birth of a child ever be considered a source of damage? And does the discourse alone on the topic of wrongful life devalue life with a disability? And these are the questions that courts have ultimately had to grapple with. And as you see, the paper is really a dialectical discussion on those, what I've called metaphysical contradictions. And courts faced with these issues have overwhelmingly rejected wrongful life causes of action, that's the Harrington type claims, while at the same time in other jurisdictions have approved those for wrongful birth, that's Cattanach. Yet, as you will see, the minority in Cattanach ultimately carried the day in Harrington based on very similar arguments where public policy and morals tended to trump questions of orthodox application of tort law. And that's in part, I think, because courts have found it more palatable to identify the loss of parental choice as an injury, as opposed to that ultimate question of whether non-existence is ever preferable to life, however burdened or damaged it might be. That's my introduction. The interesting thing I found in the paper was the quote that I think Michael or Andrew, I'm not sure, picked. That was from the Sophocles play. It's one of the very few Greek tragedies I actually did at school. But the quote here is, not to have been born exceeds every reckoning. And that's, apropos the topic here today. But the rest of the quote is that, but once a man has seen the light, the next best thing by far is to go back where he came from. Okay. Yes, in other words, you're most lucky if you've never been born, but if you are born, what you should hope for is a quick life so you can get back to where you were, that is the ground. Now that might sound fatalistic, but we're talking about Oedipus here. And it's actually the ultimate irony because, of course, Oedipus literally went back to where he came from, being Jocasta, his mother's womb. So it's actually a very clever quote. I like that. I'd hand it over to Michael.
Okay. Thanks, Tom, for that very pleasant introduction. I'm not going to walk you through the paper. It is but a sampling of the sort of reasoning that took place both in Cattanach and Melchior and in Harrington and Stevens. It's a selective quotations linked together by some odd thoughts here and there. Incidentally, the quote that I started with was one of the favourites of Schopenhauer. Eventually, he accepted that, and that was a sort of part of the Ionic Greek philosophy, for which I'm indebted, I might tell you, to Frederick Coppelson's wonderful and very readable history of philosophy in something like 14 volumes, but very, very good summary. The problem that confronted the court in Cattanach repeated itself in Harrington, and that's the reason we put the two together. Andrew and I have been involved in a long-running case in Canberra, which is based upon the Cattanach principles. But when you look at the overall position, there is really nothing to distinguish between Cattanach and Harrington, save only that you've got different people who have been injured in the tort. You've got the parents in the one case, and you've got the child itself in the other. And That is the reason why Andrew and I put in the paper that we think the High Court has gone backwards. They moved forward in a very positive way, albeit by a very slim majority in Cattanach. But 3 years later, in Harriton, they basically said, oh, we're not going to go there. And seemingly on the basis that at the end of the day, it all comes down to whether or not there was a comparator. In other words, it comes back to the old tort principle, which I think we've mentioned in the paper, that the basis of damages in a tortious action is to put the plaintiff back into the position, so far as money can, where they were before the tort took place, before they suffered injury or damage. And despite the antiquity and the sort of anachronistic nature of that principle, that ultimately seems to be underpinning what was said by the High Court in Harriton. That is to say, look, what do you compare life with? Because if you're the child suing for wrongful life, then the only comparison is death. So if life is the essential categorisation of the tort, then to put you back to where you came from really involves the quotation which started the paper. In other words, death is something which has got to be more desirable than life, and everybody seems to accept that that's something which modern society doesn't accept one way or the other. But intersecting with all of these, as you'll see in the paper, are a whole series of legal fictions. There's a whole series of judges expressing what they regard as the moral imperative of the day, expressing their views about societal values, and very little of it actually gets down to the fundamentals of tort law. There's very heavy emphasis on public policy informed by morals, but when you sit down and analyse it, perhaps Kirby got it right when he said, look, you've got to get back to the fundamentals here. How do you categorise a tortious liability? You don't categorise it by qualifying it with public policy, even though that may ultimately be an underlying and underwriting factor for the reasoning on which the judges base their opinions. You don't categorise it on the basis of the quantification of damages and how you assess it on a comparison basis. You simply have to look at, was there a negligent act which resulted in a condition for which damages may, not necessarily will be, may be applicable. Now, the damages may play out differently with different people, but it is a fundamental of the tortious liability that they're talking about, that there's got to be a duty of care, there's got to be a breach of that duty of care, and there have got to be damages that flow from it. I mean, it's as simple as that. The convolutions that the judges went through in both Cattanach and Harriton were quite extraordinary. I mean, the paper just deals with, lightly touches on the surface of some of them, and picks up, in particular, Kirby's comments in criticism of his fellow judges as to the reasons why they came to their decisions, and it's summarised in the paper. I'm not going to go there. So briefly, at the end of the day, it is a philosophical discussion which has no place in the law, in my view. I personally found the case that Andrew and I had to run in Canberra repugnant to my own personal values and my own valued judgments, but that's what we do. We're barristers, we get paid to do a job, and we do it as best we can. I might turn over to Andrew very briefly now for him to talk about his take on all of this, but I assume, Andrew, you're going to touch upon the question of Griffiths and Kirkmeyer type damages, etc., and the possibility of their availability in these sorts of cases. Is that correct? Thank you.
I mean, I think what's Thanks, Mike. I think what's left is when you're applying the legal principles, is there are wrongful birth claims available for parents. Of course, in New South Wales, it's the Civil Liability Act says that it prescribes the sort of remedies that Cattanach and Melchior achieved, because that was a sterilisation case, and you can't get damages, at least in New South Wales, for the costs of raising a healthy child, but you can get damages for the costs of raising a disabled child. And that's what we're faced with in our Canberra case, of course, is that there's a young girl who was born with a congenital disorder, which on our case ought to have been, parents ought to have been warned of before she was born, and their clear instructions, and there's good reasons for this, is that they wouldn't have proceeded with the pregnancy. So anyway, that's going to be played out, but it's a similar sort of scenario that was facing the Court of Appeal in Waller versus James, which Michael and I have talked about in the paper. In that case, that was a case where the family or the child actually brought a case with alongside Harrington and Stevens, and for the reasons because of the wrongful life decision that they lost, and then the parents brought their own cause of action. The parents had a genetic predisposition to passing on a genetic disorder, and ultimately the child was born. The breach was that the parents weren't warned of the possibility of passing on the disorder, as I understand it. When the child was born, unfortunately he was afflicted with a cerebral sinus venous thrombosis in the first few days of life. It became catastrophically injured. Now that condition is obviously not anything to do with the genetic disorder that the parents weren't warned of. And so ultimately they lost on causation. In other words, that the risk that they weren't warned of wasn't the risk that came home. Michael, what we didn't talk about in the paper, of course, is damages and the remoteness of damages. Justice Beazley didn't have to deal with that in her decision, but I think she just reviewing it just before we came on today, is that she also said that in that case, she thought the damages that were inflicted on the child was ultimately the injuries that he had were too remote from the breach, because the breach was failing to tell the parents about the genetic disorder, and that was not the damage that the child suffered. So anyway, the case that we've got though is a little bit different because the congenital disorder that the parents weren't told about was precisely, to a certain extent, what came home, and it was a condition called a tracheoesophageal fistula, which meant that there was an abnormality in the connection, and that is going to cause his kids or has caused his kids significant problems. The parents have basically lost their ability to work, and it's something that when you look at the principles, the legal principles, it's something that we think should be addressed. So,
so can you explain to us, so the Canberra case?
yeah,
So I don't know if you want to keep going.
no, please.
So in the Canberra case, you've got parents suing doctor or whoever it is
Yeah.
for the fact that their child was born with a genital problem. Congenital or genital?
Yeah, no, it's congenital.
Congenital problem. And you're saying that the quantum that's in play is the cost of raising a child for the rest of their life because of that deformity or issue.
Yeah, that's right. See, what the breach is the breach is failure to warn of the possibility of the birth defect. Right? And I mean, there's a factual contest about that.
Yeah.
But assuming that the plaintiffs succeed, then the remedy is a damage caused by that breach, which is the costs of raising the child, arguably restricted to the costs of incurred because of the disability.
Yeah, so the additional, so if it costs 100 grand to raise a kid, and it costs 500 grand this particular child,
Yeah.
you'd say 400 grand is
Yeah.
your remedy. We
Correct.
quantum it.
Yeah, well, in the ACT, there's no Civil Liability Act restriction as applies in New South Wales. In New South Wales, it would be restricted because of the effect of the Civil Liability Act.
Would be restricted in the way you say.
Yeah,
In other words,
sections.
it's the additional cost of raising the disabled child,
Yeah.
as opposed to ordinary child rearing costs.
Right.
So if you can quantify that, you can get damages under the Civil Liability Act in New South Wales.
So in ACT you get the 500.
You get the lot.
Oh.
You get the, effectively, you get the lot for the cost of raising the child, certainly at the age of 18.
Yeah.
But you also get the additional costs. In our argument is you get the additional cost of the disabled child as well.
What about care? Can you claim for care?
That's the interesting point Andrew will talk about.
I think, yes, maybe. But just getting back to the damages, I'm not entirely sure. I'm not entirely sure, Michael, whether or not. I mean, there's still an argument available about whether or not you only get the damages for the disability or the risk associated with the birth of the child that the parents weren't warned of, not all of life's consequences. And that's what Justice Beazley said in Waller and James. She didn't have to decide it, but she said the only damages that weren't too remote would have been the damages that were attributable.
But only in your
to-
case, wasn't there two children? One, they were twins.
Yeah.
One was normal
Sure.
and one was grossly abnormal.
Yeah.
So how do you differentiate between the two for care and how do you, the parents' time?
It's in terms of what they were, what the case, our argument is that the child should have been born.
At all?
The child shouldn't have been born.
Period.
So had they provided the advice they should have provided, there was available selective termination because of the nature of the pregnancy. It was a twin pregnancy, but they were different zygotes, so that they had different placenta, different everything. So it was possible to.
So that one would have survived, the healthy one would have survived.
Correct. And the other would not have been, would have been born, but born dead. So it's a horrible process, I can tell you.
Yeah, so it's a difficult argument for the parents to make out, no doubt, and their instructions are quite clear for a number of reasons, subjective reasons that can be proved looking at what they would have done prospectively before the child was born. They had family members that had disabled children. They had this wasn't a planned pregnancy. They had other kids. They were doing other things in their life at that time, and their evidence was quite clear that they would not have risked giving birth to a disabled child, and that's the risk that we are going to argue is that the right to plan your family in a way that you think is the way you want to is the right that should be protected by law.
And why don't you run into Harrington? Because that basically says you don't get damages for a damaged life. Is it a question of standing?
Because if you look at the way Justice Beazley approaches it, I don't think you can look at it from a Harrington perspective. I think you've got to look at it from because it's the parents' damage, and the damage is, what, but for the breach, what wouldn't have occurred, as long as the damage is not too remote. And so causation looms large in this case. Firstly, the parents have to prove that they would have not proceeded with the pregnancy, and secondly, that the termination was available to them, which is also problematic. But you know, at least according to Justice Beazley, the right to claim one's family is the right to be protected at law, because the reason why they lost in Waller and James, as I think I said, is because the breach wasn't related to the loss, and so whereas in our case,
That's a Wallace and Campbell point.
correct, precisely.
To what extent is it important in your case that the eventual termination and the death of the baby would have occurred very late? I mean, you know, we're all sort of familiar with the idea of the morning after pill. You know, it happens a couple of days after, and no one feels, you know, that sort of planning doesn't generate the sort of heat that, you know, a termination at a very late stage does. I mean, how much does that impact on your...
Well, it's a significant hurdle on causation. Michael took evidence from a doctor in America via video link, because at the end of the day, that might have been the only option available to the parents, so they would have had to have gone overseas. So we had to track through what was available and what would have been practically available to them.
Why is a potentially disabled life worth less than a fully able life?
I don't think it is. I don't think that's the. I don't think that's the point.
What's the point?
The point is that the obligations of the parents to look after the child become more expensive, if I can put it that way. They are burdened with something that a cost or damage, pecuniary cost, that they would not have, that they didn't sign up for.
Is it their choice though?
Well, absolutely, it's their choice. This is a medical procedure. These parents were in the care of a high risk maternity unit in Canberra. There was a high risk pregnancy. There were some signs of significant risks of a disabled child in utero. The nature of those risks and what we can actually prove they ought to have been told about, or what was discoverable is an issue in the case. But the parents are clear what the actual condition that was picked up, even on the defendant's case, which is a tracheoesophageal fistula. On our case, the parents weren't told about it.
Is there any
And so-
dispute about that?
Yeah, that's one of the.
They say they were told, but very late. And
Right, too late to do it very late.
effective.
What happens if your disabled child turns out to be Stephen Hawkins? Do you get damages?
It won't be. It's no Stephen Hawkins in this case, unfortunately.
Regrettably,
Sadly.
the child's not turned out to be another Stephen Hawkins.
Spent the last 4 weeks in hospital for procedures related to the TOF, so specifically related to the condition, which they weren't warned about. So that gets back to both causation and remoteness. We believe, if the facts are made out, then the law says that they're entitled to a remedy for any the damage that was caused.
So the mother was already pregnant at the time that the negligent medical...
Yeah, this
isn't a sterilisation case. This is a case of a detectable abnormality, which we say was detected, but they were not advised of it. Even had they been advised of it, it was still very late. And you'll see there was a discussion in the paper about late termination, practical difficulty in obtaining that in Australia. You have to pass through ethics committees.
Right.
And again, that's a value judgment on the part of the ethics committee. For example, they had found that if it's trisomy 16 or Down syndrome or something like that, that's justification for it. But it wouldn't be justification for it to have, at least in one instance that we know of, a cleft palate. But that ultimately, late abortion was performed on that child, solely for the health of the mother. So it's all full of, you know, value judgment, social acceptability and otherwise. And indeed, I think we make reference to the paper to one of the expert doctors who was called, who performs late abortions after the approval by the clinics, by the ethics committees, who said, he looked around the courtroom and he said, "Is the press here?" He wasn't prepared to answer any questions about how it happens and why it happens, if it was going to be broadcast, because it's all, at the moment, it's all sub rosa. I mean, this is all going to change within 10 or 15 years as the societal values change, but at the moment, that's where we seem to be at. It's unfortunate. There's no logical reason why early abortion could be, in a sense, early abortion is different to late-term abortion if you accept the legal fiction that the medical profession appears to work on, that so long as it's in utero, it's not a life in being. And that's why they make sure that, in a horrible fashion, the fetus, they commit feticide, so that the fetus is not born alive.
Why is that a legal fiction?
Because, in my view, that's only my personal view, once a child is viable, which is usually about 24 weeks, or albeit it may only be for a short period of time, they're entitled to life. Once they're viable, it doesn't matter whether they're in the womb or not, but the fiction that the medical profession appears to work on is that so long as they're in the womb, they're still a fetus. They're not a living. As soon as they pop out, they've got all the obligations of the medical profession in relation to a life in being. They've got to resuscitate, they've got to do everything else.
I'm interested in that after a recent documentary on SBS that indicated that even very early on, heartbeat, this has been indicated life. If you go back and look, if you go back and look through, get Frederick Coppelson, read the 11 volumes of the history of philosophy, you will find there's been a varying shift of whether it's life ab initio, from the moment of conception, from the time it becomes an 8-cell blastocyst, and therefore can continually be capable of actually growing in a petri dish to some degree, or whether it's sometime when the heart starts, or sometime when the consciousness of pain starts. You know, everybody's had a different view about it. It's a whole, but I mean, my own personal view is it's ab initio, from conception. I mean, if you've got a life in being from that moment onwards, it's potentially a human being, and it will become one absent any intervention. But that's why I say I find some of this case that we're running a bit difficult.
I think we wouldn't be running this case but for the principles as enunciated by President Beazley. I mean, the legal right that is sought to be protected is the right to plan for one's family. So, at the end of the day, and it is legal to perform a late termination. There's ethics committees, as Michael said, and surprisingly, when you look at the statistics for late terminations when parents are warned of a TOF, which is the tracheoesophageal fistula, which is surgically correctable, and children ought to survive, albeit with some varying degrees of problems. It's about 10% that parents choose to not proceed with a pregnancy. And if there's genetic disorders such as Down syndrome or dwarfism or other things, then the varying different statistics on that. But not a very nice topic, but it's, and thankfully no one in this room has had to deal with these issues, I take it, in their own life. But it's certainly a topic, it's certainly something that happens.